Marcoleta.
Thank you, Mr. Chair. Doon po sa paghingi po natin ng record, let us be guided by two items. Dalawa po yung agreements to arbitrate. Ang isa po ay may petsang 1987, yung isa po 1993. Gusto ko pong balikan yon para magkaroon po tayo ng guide kung ano pong dokumento ang hinahanap natin. Dalawa po kasing items ang binabanggit dito sa dalawang arbitration agreements. Babasahin ko na po, medyo malabo lang, pero ang sabi po rito doon sa 1987 arbitration agreement, number 1, that they submit the claims of ABS-CBN for the return of the television and radio stations of ABS-CBN to a board of administrators composed of a chairman and 2 members for final adjudication and settlement, receiving into a future date to be agreed upon by the parties, the submission of other claims related thereto. Number 2, for the rentals and other forms of damages for the use of said facilities by the Marcos government, etc., etc. Mr. Chair, dalawa po ito eh. Ang inihingi po dito, kauna-unahan, yung claims doon po sa pagmimay-ari. Pangalawa, yung claims po sa rental and damages. Maski na po doon sa pangalawa, ito nga yung 1993, dinistinggi rin po doon eh. Sabi po rito, whereas the ABS-CBN has filed a request with the Office of the President on April 18, 1986 and reiterated in a letter dated October 18, 1986. 1. For the return of all its television and radio stations together with the operating equipment and frequencies which were closed down upon the declaration of martial law and sequestered by former President Ferdinand Marcos on September 21, 1972. Pangalawa po, for rentals and other forms of damages for the use of said facilities by the Marcos administration, etc., etc. Dito po, lumilitaw po ang nangyari rito. Parang ang compromise agreement, yung pangalawa lamang po na saknong nitong arbitration agreement. Kahit kailan po, walang binabangkit doon sa kauna-unahan na objective kung bakit nagkaroon ng arbitration agreement. Ang sabi po, for the return of all the television and radio stations together with the operating equipment. Very silent naman po yung compromise agreement pagdating dito. Ang nalalagay lang ay yung pong rentals, damages, kaya nga nagkaroon po ng claims between the two parties, the government of the Philippines and ABS-CBN. Nasaan na po yung kauna-unahang item na kung saan dapat makita natin muna na-establish po yung ownership. Yun po yung sinasabi ko kanina. Kaya kung meron po talagang arbitral award, unang-una na po ipakikita, maaring na-establish na talagang ABS-CBN ang may-ari. At saka po lang lilitaw yung pangalawa. From the determination of ownership, malinaw na malinaw po, meron na silang right talaga to claim damages. So sabi nga natin, paano nauna po yung kalesa sa kabayo? So, ang inihingi po nating record, Mr. Chair, ay yung magtetestigo sa dalawang bahagi ng arbitration agreement na pinagpasyahan nga, na-determine ng walang kaduda-duda na ang pagmimay-ari ng pasilidad na kine-claim ng ABS-CBN na patunayan po sa ebidensya, sila po. Pangalawa po, doon pa lang magkakaroon ng compromise agreement. Parang hindi po kumpleto. Kaya pong inihingi natin record po. Salamat po sa paglinaw, Mr. Chair.
Maraming salamat.
Chairman Alvarez, if I may clarify.
Yeah, please proceed po, Chair Mike.
Yes, Chairman Alvarez, ang binabanggit po ng ating Honorable Marcoleta, yun din po yung dokumento na hinihingi natin kay Attorney Belsi ng Board of Administrators, Board of Arbitrators. Doon po makikita natin yung mga dokumento. Kung meron man po, kung binanggit na rin po ni Attorney Redonia nung mag-usap, sabi niya meron daw ginawang audit, doon po makikita natin lahat, officially, from the Board of Arbitrators. Sa kaso naman po ni Congressman Villago, yung binabanggit po niya from the Makati Regional Trial Court. Meron po naman din dito sa submission ng ABS-CBN, but we wanted to make it official from the Makati Regional Trial Court. And also from the PCGG, may mga hinihingi din pong dokumento kanina tungkol doon sa mga usapin dito po sa ating mga dokumentong pangangailangan. So yun po, Mr. Chairman, yung mga dokumento na sinabi na rin po naman natin sa ating Committee Secretariat. Thank you, Mr. Chairman.
Maraming salamat sa clarification na Kong Mike. Reiterate ko lang sa ating COMSEC na i-take note po yung lahat po ng mga hinihingi para po maging malinaw po at ma-furnish po natin mga members natin as soon as possible. So para po sa pinakaunang magtatanong, dito sa ating sunod na issue is yun, on the 50-year constitutional limitation of a franchise. Pakinggan po muna natin ang ABS-CBN sa kanilang pahayag tungkol sa issue na ito. ABS-CBN, you have the floor.
Mr. Chair, may I request that Attorney Ayo Bautista be recognized.
Attorney Ayo Bautista, you are recognized. Unmute lang po si Attorney Ayo.
Magandang hapon po. Narinig po ba ninyo ako?
Malinaw po, Attorney Ayo. Please proceed po.
Salamat po. Good afternoon to the Honorable Chairman of the Joint Committees. Good afternoon to the members of the committees and sa lahat po ng ating mga congressmen at congresswomen. Ang sinasabi po ay dapat i-deny ang franchise application ng ABS-CBN dahil po ito ay lumalabag sa Section 11, Article 12 ng ating 1987 Constitution. Specifically po, sinasabi na ang prangkisa daw ay dapat 50 years lang. At kung ang isang public utility ay mag-ooperate in excess of 50 years, ito daw ay labag sa batas. With due respect, we disagree with this proposition. Ang nakalagay po sa Section 11, Article 12 ng 1987 Constitution is as follows, and I will read it. No franchise, certificate, or any other form of authorization for the operation of a public utility shall be granted, tapos may mga salita po, for a longer period than 50 years. Ang interpretation po nitong provision na to, ang issue ngayong araw with respect to the public utility 50-year limitation. Ito pong Section 11, Article 12 ng 1987 Constitution ay nanggaling sa Section 8, Article 13 ng 1935 Constitution at sa Section 5, Article 14 of the 1973 Constitution. Yung tatlo pong provisions na ito ay exactly the same, similarly worded. Wala pong pinalitan sa pananalita ng provision na ito. Ang aming pong submission is that on its face, the 50-year limit applies to each franchise certificate of authorization and does not prohibit the grant of a new franchise to the same entity. Hence, the Congress may grant several franchises to the same public utility. Wala pong pagbabawal dito. Yun po ang bare reading of the provision as it is written. Ang sinabi po ng Korte Suprema ay, and I quote, where the words of a statute are clear, plain, and free from ambiguity, it must be given its literal meaning and applied without attempted interpretation. It is a well-settled principle of constitutional construction that the language employed in the Constitution must be given their ordinary meaning except where technical terms are employed. Ito po ang ruling ng Korte Suprema sa Chavez versus Judicial and Bar Council, 17 July 2012. Let's presume na hindi po klaro yung provisions on the 50-year limitation. Ang sinabi po ng Supreme Court, in the construction of a doubtful and ambiguous law, and we submit po na hindi naman doubtful at ambiguous itong provision na to, the contemporaneous construction of those who are called upon to act under the law and were appointed to carry its provisions into effect is entitled to very great respect. Yan po ang ruling ng Supreme Court sa Ting versus Central Bank of the Philippines, 24 September 1958. Ngayon, sino po ba ang government agency na nag-i-implement at nag-give effect to this provision? Sino po ba ang nagbibigay ng franchises? Alam po natin lahat that it's Congress. At ang mga ginagawa ng Congress sa prangkisa, una dadaan yan sa Legislative Franchise Committee, pagkatapos dadaan sa plenary Congress itself. Pag makalipas po kung makaraos po yan sa Congress, dadaan naman po yan sa Senado, and after the Senate, it goes to the President who will either decline or approve the grant of franchise. Yun po ang proseso ito. So, tinignan po namin ang mga jurisprudence ng Supreme Court with respect to the construction of the subject provision. Wala po kami nakita. So, ang pinag-aralan na lang po namin, ang research namin, ay yung mga prangkisang binigay ng Congress through the years. At may I add na yung gaya ng sinabi ko ng umpisa, no, itong provision na to ay nasa 1935, 1973, at 1987 Constitution. Ang ibig sabihin po nun, yung framers ng 1987 Constitution were satisfied with the implementation, interpretation, construction of the government with respect to the franchises, specifically on the 50-year term. Ngayon, nag-research po kami ng mga prangkisa na binigay na ng Kongreso. Ito po, we based on the website at congressional records. Ang Manila Electric Railroad and Light Company po, ang Meralco, ay 126 years na po. Unang-una sila nabigyan ng prangkisa, Act number 484, noong October 20, 1902. Ganun na po katagal pala ang Meralco. Ang Philippine Long Distance Telephone Company, PLDT po, ay 100 years na po in operation. Ang kanilang unang prangkisa ay nakuha noong November 28, 1928. Totaling 100 years ang PLDT. Ay tinignan din namin po ang mga power companies, light companies, hindi na sa Luzon, kundi sa buong Pilipinas. Ang Visayan Electric Company po, VECO, ay 102 years na po. Ang una pong binigay na prangkisa ay through Act 3499, issued on 8 December 1928. Sa Davao po, Light and Power Company, 95 years na po yan. 95. Nagulat nga po ako, ang tatanda na pala ng ating mga public utilities sa buong Pilipinas. Ang una nilang prangkisa ay nakuha noong November 26, 1930 by virtue of Act number 3716. Ang Philippine Airlines po, ang ating national carrier, ay 93 years old na po. It started on November 14, 1935 through Act number 4271. And it has been continuing its operations as a national flag carrier since 93 years ago. Pati po sa Cotabato, nagulat po ako. Cotabato Light and Power Company, isang taon na pala yun. 100 years na po. Nag-umpisa sila June 18, 1939 through Commonwealth Act number 487. And down the line po yan, no? Tinignan rin po namin ang mga telco, radio broadcast, TV broadcast, at media. Ang PT&T po ay 76 years old na. Ito po ay telecommunications company. Ang Catholic Bishops' Conference po na meron broadcasting and TV stations ay 75 years na po. Ang Iglesia ng Cristo, meron din po silang radio stations. Una silang binigyan noong June 16, 1965, and they have a total of 75 years. Ang GMA7 po, sila mismo po, sinasabi nila sa kanilang mga announcements, they are 70 years old in their operations. So, with the rest of the broadcasting company po, ABC5 is 62 years, IBC13 is 70 years. Sa totoo po, nung binilang namin lahat ng TV broadcast media stations, lagpas po 10 ang meron pong franchise terms na in excess of 50 years. So ang aming pong submission ay wala pong nalalabag na constitutional provision kung bigay po yung aming application for a new franchise exceeding 50 years, or in operation 50 years. Kasi sinasabi po, 60 years na kami ngayon. Ang malaki pong in closing, I want to highlight na kapag ang finding po ng Kongreso ay kailangan 50 years lang in operation ang isang public utility, lahat pong itong mga korporasyon na binanggit ko ay violative of the Constitution yung kanilang prangkisa. So wala na tayong Meralco, wala na tayong PLDT, wala na tayong Philippine Airlines, wala na po tayong mga TV stations, wala tayong radio stations. Kaya napakabigat po yung bintang na kailangan 50 years lang ang public utility. Sa totoo lang po, sa SEC, any corporation can exist for as long as it is renewing its articles of incorporation and filing for an extension. Ang nakalagay po sa ating saligang batas, no franchise, no certificate, no authority shall be in excess of 50 years. Kung ginusto po ng constitutional framers na ilimit lang yan sa 50 years, sasabihin po nila categorically na a public utility company or a telco company or a media company cannot operate more than 50 years. Yun po ang aming submission. Marami pong salamat.
Thank you, Attorney Bautista. The first to interpolate.
Kong Mike,
I'm sorry, Chairman Alvarez.
ang una pong mag-interpolate ay si Congressman Lawrence Fortun na may dagdag na 5 minuto na binigay ni Congressman Amatong. Congressman Fortun, you have 10 minutes.
Mr. Chair, can I be heard now?
Yes, malinaw po. Please proceed po.
Yes, Mr. Chair. Ang una ko pong tanong, Mr. Chair, ay para sa Department of Justice. Meron po ba tayong representative from the DOJ?
Comsec, mayroon ba tayong taga-DOJ na kasama ngayong hapon?
We have a representative from DOJ, SECT, and State Council Cambaliza.
Okay. So any of our representatives from the DOJ may answer, Mr. Chairman. Babalikan ko lang yung Article 12, Section 11 ng ating Constitution. It says, no franchise, certificate, or any other form of authorization for the operation of a public utility shall be granted except to citizens of the Philippines or to corporations or associations organized under the laws of the Philippines, at least 60% of whose capital is owned by such citizens. Nor shall such franchise, certificate, or authorization be exclusive in character or for a longer period than 50 years. Tanong ko sa DOJ, based on this provision of the Constitution, can a corporation be issued a single franchise for a public utility, say mass media, for a period of 50 years? Diretsong 50 years for a single franchise. Because the practice has always been for Congress to grant 25 years franchise. I have not known of any Republic Act na agad-agarang 50 years ang binibigay. Is it legal or is it constitutional to issue a franchise for a period of 50 years?
Magandang hapon, Mr. Chairman, at magandang hapon, Congressman Fortun. Salamat po sa tanong mo. Unang-una, ang provision nito ng Constitution, in Article 12, Section 11, specifically nag-a-apply ito sa public utilities. Ngunit, maaari nating sabihin na mag-a-apply ito by analogy sa mga mass media company. Specifically dun sa tanong ninyo, kung pwede bang exactly 50 years ang franchise na ibibigay ng Congress sa isang aplikante. Para sa DOJ, maaari naman po ito gawin. Ang limitasyon na linalagay ng Constitution ay 50 years at ang Kongreso ang Congress ay may kapangyarihan na magbigay ng kahit anong term as long as hindi ito lumampas ng 50 years.
So a single franchise can be for a period of a maximum of 50 years, no? That's what we're saying. Now, after po mag-lapse itong 50 years na binigay ng Kongreso sa isang korporasyon, can Congress again issue another franchise? This time for a shorter period, say for 25 years.
Yes, Your Honor. Congress can once again issue a franchise to the same applicant, to the same grantee. Tulad ng sinabi ni Attorney Bautista ng ABS-CBN, ang qualifier, ang limitation, ang 50-year limitation under the Constitution pertains to the franchise itself and not to the grantee. And for that renewal franchise, for that new franchise, once again, Congress has the discretion to fix the term of that franchise as long as that term does not exceed the 50-year limitation.
Okay. In other words, what is not allowed is for Congress, to give a single franchise of a period exceeding 50 years. But it can be an accumulated period of more than 50 years, basta iba-ibang prangkisa, none of which exceeds 50 years. No? Klaro yon.
That is correct, Your Honor. Congress can issue multiple franchises that collectively can exceed 50 years as long as the individual franchises do not exceed 50 years.
Okay. Tatanong ko lang din po. When the Constitutional Commission crafted the 1987 Constitution, it is safe to assume that when the members included this provision in the 1987 Constitution, the Commission was completely aware that this provision was exactly the same provision provided for in the 1935 and 1973 Constitutions. Is that correct? Kasi siyempre, nung ginagawa nila yung 1987, tinitingnan nila yung 1935 and 1973 Constitutions. And having that in mind, the Constitutional Commission knew that in 1987, there were already corporations with existing franchises with a period of over 25 years. No? Assuming in 1987, there's an existing corporation with a franchise of 25 years earlier and renewed for another 25 years. At kung ang naging intent ng ating Constitutional Commission is to limit the franchise to only 50 years, the whole operation for only 50 years, the Commission was well aware na in a few years, marami dito ay magsasara na. Is that correct?
Your Honor, it's difficult for us to go into the minds of the framers of the Constitution, but we could say that your premise, your presumption that the framers of the Constitution were aware of the existence of certain entities that operated public utilities beyond 50 years, we would say that is a good supposition.
Mr. Chairman,
Yeah.
Mr. Chairman, Chairman Alvarez.
Pangrimulya.
Yes, I cannot understand the quality of the reception of the words of ASEC are not clear. Can we have a better signal, please? Because I cannot understand anything you say.
ASEC T.
Your Honor, I opened the door already. Hopefully, the signal will improve.
Sige po. Kung Fortune, please proceed po.
Yes. In fact, Mr. Chair, my question to the DOJ, in fact, if it was the intent of the Constitutional Commission to limit franchises to a period of only 50 years, no, max na yon. Siguro 5 years after the 1987 Constitution was promulgated and became effective, marami na sa mga corporations na ito ay dapat nag-shutdown na, nagsarado na dahil inabot na sila ng sobra ng 50 years.
That is correct, Your Honor. Counsel for ABS, Attorney Bautista, pointed to several examples of entities that have operated for more than 50 years, under multiple franchises, and had the interpretation been, had the view been that the 50-year limit applies to the grantee, it would be fair to suppose that those entities would have long shut down.
Yes. In fact, in 1987, when the Constitutional Commission was crafting a new constitution, marami sa mga korporasyon na to, 50 years in operation na. If that was the intent of the Constitution to limit it to 50 years, a year later, sarado na tong lahat na to. No? Now, I shift my question now to the National Telecommunications Commission, NTC. May NTC po ba?
Comfort 2, nandyan po yata si Commissioner Cordova.
Okay. Para sa NTC, may mga binanggit kasi kanina na mga corporations na si Attorney Bautista. Specifically, no, yung mga broadcasting corporations. He mentioned about GMA and some others. Pero hindi na na-mention yung iba. But I also made my own little research, no, from the website also of the House of Representatives, so from Congress. And I also saw other broadcasting corporations, no? Ang operations ay sobra-sobra na talaga. And I'd like to ask the NTC, no, tungkol dito. For example, the Manila Broadcasting Corporation was first issued a franchise in 1950. Tapos in 1994, meaning 44 years later, in 1994, binigyan ng another 25 years. So diyan pa lang lagpas na. And in 2018, another 25 years. So that makes it 50 plus 44, 94 years na lahat-lahat ang prangkisa binigay sa Manila Broadcasting Corporation. Then we have Cebu Broadcasting, 1950, ang unang prangkisa. In 1995, that's 45 years later, 25 years na naman na prangkisa ang binigay. And in 2019, only recently, 25 years again. So that's a total already of 50 plus 45, 95 years, no, na period ng prangkisa. You have the Philippine Broadcasting Service, 1950, binigyan ng prangkisa. 45 years later, another 25 years. And 25 years later, another 25 years. I have a long list, no, of many broadcasting corporations whose operations are even much, much older, no, than that of ABS-CBN. Kasi I understand ABS-CBN got its first franchise only in 1950. Itong mga to, mas matagal pa yung iba kaysa ABS-CBN. Now, ang question ko sa NTC, has there been any instance that the National Telecommunications Commission questioned the issuance of these franchises that have exceeded already the period of 50 years pag pinagsama-sama mo lahat ito?
Can you hear me, Your Honors? Malinaw po ba?
Malinaw, Commissioner Cordova. Please proceed.
Okay. Your Honors, what happens po kasi is that once we get franchise from Congress, at natanggap po namin ito, and if it's a valid law, duly enacted by Congress, duly signed by the President, or pinalapse into law po, then we recognize the validity of that franchise na inisyu po ng Congress.
Was there any instance that the DOJ, for example, not only the current DOJ, but the previous leadership of the DOJ, advised the NTC to refrain from giving appropriate authority, no, to these corporations that have been issued franchises by Congress on the ground that the franchise given by Congress already violated the Constitution because the period given to these corporations to operate broadcasting companies have already exceeded 50 years. Wala po nangyaring ganon ever since.
As far as I know, Your Honors, wala po akong naalala nangyari na ganon, Your Honors.
Thank you very much for that. Para po ulit sa DOJ. In other words, sirs, Congress, no, when it gave several franchises and renewed these franchises, tapos yung accumulated period na to ay sobra-sobra na sa 50 years, Congress action of passing legislations, no, giving franchises and renewing these franchises for periods exceeding already 50 years, Congress's action has always been constitutional. Is that correct? From the DOJ.
Paki-unmute yan.
Okay, I'm unmuted already, Your Honor. Yes, Your Honor. The 50-year period pertains to the franchise itself. So Congress has acted within the bounds of the Constitution in renewing the franchises of the same entity for which collectively reach periods that exceed 50 years.
Kasama na rin po ang pagpirma ng ating Pangulo sa mga batas na ito, no? Mula nung 1920s hanggang sa kasalukuyan, and under the current administration, I have here, as far as broadcasting corporations or broadcasting companies are concerned, we have Manila Broadcasting Corporation 2018, tapos Cebu Broadcasting Corporation 2019, ang Philippine Broadcasting Service noong 2019, itong Far East Broadcasting Corporation ng 2017, GMA 2017. All of these were signed into law by our President Rodrigo Duterte. In other words, the President was right, no, in signing this into law, and his action of signing these Republic Acts into law was not unconstitutional.
That is correct, Your Honor. Both Congress and the President acted within the bounds of the Constitution in renewing those franchises, even if renewal would mean that the entity would operate beyond 50 years.
Okay. And finally, Mr. Chairman, as a last question, in the case of ABS-CBN, if Congress grants ABS-CBN another franchise of 25 years, itong dinidinig natin ngayon, and I feel very strongly that after all these deliberations, Congress, no, would eventually, no, issue or pass a legislation giving ABS-CBN a fresh franchise of 25 years. If we do that, is that action by Congress constitutional?
Your Honor, that action of Congress would be constitutional insofar as the 50-year term limit for franchises is concerned.
Okay. And if the President signs that into law or does not act on it and the same lapses into law, that new law cannot be attacked as unconstitutional for having exceeded the period of 50 years already.
That is correct, Your Honor. That new law cannot be assailed for being unconstitutional for the ground of exceeding the 50-year limitation.
Okay. Thank you very much to the DOJ and to the NTC. Mr. Chairman, that's all. Thank you for this opportunity.
Thank you, Congressman Fortun. Next po sa list natin si Congressman Caloy Zarate na binigyan din ng additional 5 minutes ni Congresswoman Arlene Brosas. Kong Zarate, you have 10 minutes.
Mr. Chairman is out of the plenary hall.
Balikan
Out of the meeting room.
Balikan na lang po natin si Kong Zarate. Punta na po muna tayo kay Congressman Marcoleta na binigyan din ng additional time ni Congressman Ebcas, Datol, De Jesus at Guya. Congressman Marcoleta, you're recognized.
Maraming salamat po, Mr. Chair. Ang pinag-uusapan po natin ngayon ay itong provision sa ating saligang batas, Article 12, Section 11, na kung saan ay sinasabi nga po yung phrase na or for a longer period than 50 years. Dito po kasi, talagang sinasabi niya explicitly, no longer period than 50 years. Ngayon po, ang sinasabi natin, katulad po nung ako'y unang tumindig dito, Ang sabi ko, kung ang ABS-CBN ay mag-aspire pa ng panibagong prangkisa, baka babangga na sa provision na ito. Bakit ko po sinabi yun? Sapagkat sa totoo lamang po, dalawa po ang magiging interpretasyon dito. Alin man dito is within the complete prerogative of Congress. Yung pong restrictive or strict interpretation o kaya yung liberal interpretation. Totoo po na in the final analysis, it will be Congress who will use its discretion kung palalawigin yung maximum na 50 years. At sa maraming pagkakataon, totoo rin po na lumampas ang maraming mga kumpanya sa limit na yon. Bakit ko po sinabi, in particular, ang ABS-CBN sa aking palagay ay hindi na kailangang lumampas pa doon sa limit na yon. Mr. Chair, in my own analysis, I am applying the restrictive and strict application or interpretation of this provision of the Constitution. Unang-una po, isa-isa po nating ipinakikita yung nakikita nating napakaraming paglabag sa ating mga batas, lalong-lalo na po sa ating saligang batas. Kung discretion po ng Congress ang mag-extend, discretion din po ng Congress na tingnan niya na maaaring hindi na po niya extend. Bibigyan ko po kayo ng halimbawa. Ito pong sulat ng ABS-CBN sa ating Chairman, Honorable Franz Alvarez, na may petsang May 28, 2020. On the issue, does the ABS-CBN application violate the Constitution requiring that franchise should only be for 50 years, considering that the company has allegedly been using a legislative franchise for more than 63 years? We submit here a list of companies granted legislative franchises. Ginawa po nila itong Annex G. At dito nga po sa Annex G, binanggit kanina ni Congressman Fortun, nauuna po rito yung Manila Broadcasting Company at yung 12 po na nasa baba. Pwede ko po bang itanong sa ABS-CBN, ito po bang 13 mga kumpanya na kinalap ninyo na di umano'y lumagpas pa sa 50 years? May nilabag po bang batas ito sa record ng Kongreso? Nung po bang ito ay pinagdidebatihan, and when all these companies in their applications for franchise within so many periods, lumitaw po ba yung maraming paglabag? Halimbawa po, Manila Broadcasting Corporation. Hindi ba dapat kayo pong magpatunay na meron silang paglabag? Hindi po kami ang gagawa nun. Kayo po dapat ang nagbigay sa amin ng katibayan na lahat ng 13 ito ay lumabag din sa napakaraming mga batas. Kung pwede nyo ngayong questionin ng legislature, and dami rin palang nilabag nitong mga ito, bakit kami? Ayaw nyo kaming pagbigyan. Meron po bang isa man dito sa 13 kumpanya na nilista nyo rito? May papakita nyo sila, lumabag po sila, at sa kabila ng mga paglabag binigyan sila ng prangkisa sa maraming pagkakataon. Mr. ABS-CBN?
Mr. Chair, hindi ko po masasagot yan dahil wala naman ako sa proceedings ng franchise application po nila.
Yun nga po. Yun nga po Kaya po binigyan ng higit sa 50 years. Wala pong paglabag. Ito lamang po yung most laudable conclusion dito Kaya po, ang sinasabi ko nung ako'y unang tumindig, mukha pong ang Congress ngayon, baka bigyan po ng mas istriktong pananaw yung 50 years na yon. Ang katotohanan po nito, wala naman po kasing, maski po tingnan po ninyo yung record ng Constitutional Commission of 1986. wala pong binanggit na dahilan kung bakit napaka-strict niya na 50 years. Wala pong sinabing renewable of another period. Basahin po ninyo yung Constitutional Commission records. Hindi po nakalagay. Pwede po bang matanong si Attorney Bautista kung meron po siyang nakitang discussion on the intent of the framers of the 1987 Constitution, kung bakit po sinabi ng Constitution na for a period or for a longer period than 50 years. Meron po bang explanation doon ang framers ng Constitution, Attorney Bautista?
Good afternoon po, Congressman Marcoleta. Salamat po sa tanong niyo.
Meron po record o wala po?
Ano po yun?
Doon po sa phrase na or for a longer period than 50 years. Ito po kasi yung limit. Meron po bang discussion o meron po bang paliwanag kung bakit sinabi ng mga framers ng Constitution na hanggang 50 years lang?
Wala pong sinabi. Ngunit, gaya po ng in-explain ko earlier, yan pong 1987 framers of the Constitution.
Ito yung tanong lang ko.
To know that under the 1935 and 1973 Constitutions, which have exactly the same wording as the 1987 Constitution.
Attorney, ang sagot niyo po, wala po, di ba?
As to how the Congress, the Senate, and the President have interpreted and implemented that provision. Hindi naman po nila pinalitan. Kaya ang amin pong intindi is they are accepting the way Congress, the Senate, and the President through those many decades have interpreted and implemented the 50-year provision, which is to limit it to the franchise or certificate only and not to the operation of the public utility. At isa pa po, Congressman Marcoleta.
Sorry po, Attorney. Para hindi po tayo magtagal, kung ano po yung tinanong lamang, ang tanong ko lamang po sa inyo, meron po bang further discussion? Ang sabi po natin, wala. Yun lamang po.
Wala po. Pero kailangan po bigyan niyo kami ng pagkakataon na magsalita rin po.
Ito nga po, may susunod pa po akong tanong eh.
Okay po, sige po.
Okay. Wala rin po siguro nakalagay sa discussion ng mga intensyon ng ating framers ng 1987 Constitution tungkol sa pagpapalawig. Ang totoo nito, wala pong sinabi ron kung palalawigin pa ng the same year. Hindi po ba totoo na wala ring record tungkol doon, Attorney?
Wala rin po. Sa totoo po, pati sa Supreme Court, wala kaming nakita.
O yun nga po, susunod ko pang tanong sana, meron na po bang desisyon na nanggaling sa Korte Suprema na kung saan napagtalunan doon at in the final analysis, the Supreme Court made a decision explaining that the 50-year franchise limit is renewable. Wala pa pong kaso ngayon eh.
Wala po.
Salamat po. Bakit ko po sinabi na kung ako pong tatanungin ninyo, ay ililimit ko na lamang sa 50 years. At hindi ko na po papalawigin. Sorry po. Kabisado po ba ninyo, Attorney Bautista, yung Republic Act 5730?
Ano po ang title niya? Hindi yata.
An act amending the title and certain sections of RA 511 entitled An Act Granting Bolinao Electronics Corporation, etc., etc.
Hindi po ako familiar dyan.
Okay po, para po malaman po ninyo, ang ibig ko sabihin, nakalagay po kasi sa Section 1 noon, subject to the provisions of the Constitution, the ABS-CBN Broadcasting Corporation is hereby granted a franchise for a period of 50 years. Ulitin ko po, ABS-CBN Broadcasting Corporation is hereby granted a franchise for a period of 50 years from the approval of this amendatory act. Ang date po nito, Atty. Bautista, is June 21, 1969. Familiar po ba kayo sa Republic Act 5731, Atty. Bautista?
Hindi po.
Ito po ay batas na pinagtibay June 21, 1969 uli po. Kaya parehong araw po, nung binanggit ko kanina, ang title po, An Act amending the title and certain sections of Republic Act numbered 1343, entitled Granting the Manila Chronicle a Permit to Construct, etc., etc. Sa Section 1 po ng batas na ito, babasahin ko, subject to the provisions of the Constitution, the Chronicle Broadcasting Network is hereby granted a franchise of 50 years from the approval of the Amendatory Act. So kanina po, may 50 years, dito po another 50 years, 100 years na po yun. Atty. Bautista, kabisado po ba yung Republic Act 5733?
Hindi po.
Ito po may petsang June 21, 1969. Pare-pareho po ito, isang araw lang po, 3 batas ang pinagtibay. Ang title po nito, An Act amending the title of certain sections of Republic Act number 512, entitled Granting the Bolinao Electronics Corporation a temporary period, etc., etc. An act granting ABS-CBN Broadcast Corporation a franchise to construct blah 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 for a period of 50 years. Ito pong 3 batas na ito, Atty. Bautista, para sa ABS-CBN po lahat ito. Hindi po totoo na nung kayo'y mag-merge ng Alto Broadcasting Corporation at saka yung CBN, isang prangkisa lang po yun. Kapag sinuma ko po ito, 50 plus 50 plus 50, ito po yung 150 years. Kanina po sabi ni Congressman Fortun, wala pa naman daw naging batas na kagad binigyan ng 50 years. Ito po 3 batas na ang recipient po is ABS-CBN Corporation and Chronicle Broadcasting Network. 150 years po ang suma ko. Ngayon kung bibigyan pa po kayo ng another 50 years, 200 years na po yun, Atty. Bautista. Napansin niyo po itong 3 batas ito.
Congressman Marcoleta, maaari po ba ako magsalita?
Sige po.
Salamat po. Yung pong binabanggit ninyo ay mga batas na pinasko ng Kongreso at inaprubahan ng Presidente ng Pilipinas. At yung sinasabi ninyo, pagpalagay na natin pong totoo, kasi po sinasabi ko, inaamin ko, hindi ko alam, I'm not familiar with the provisions of those laws which you cite. But if it is true that you're saying that ABS-CBN was given 50 years or Chronicle Broadcasting was given 50 years or whatever, that reinforces our argument that we can exist for more than 50 years. That supports our theory, our position, that we can go beyond 50 years. It does not diminish or weaken our position. On the contrary, it reaffirms our position. At yung pong sinasabi ninyo na 50 years, ang bintang po ay hindi po dahil we violated any law or the other mass media companies violated any law. Ang subject tulong natin ay Article 12, Section 11 of 1987 Constitution. Whether a public utility or a mass media company can operate more than 50 years. Given na po that you have the discretion to grant our franchise or not, hindi po namin kine-question yun. Ang sinasabi lang namin ay kung i-deny ninyo, hindi po dapat dahil nilabag namin ang Section 11, Article 12, 1987 Constitution. Pwede po magsabi kayo ng ano pa, kahit na walang dahilan kung gusto ninyo, i-deny ninyo yung frankisa namin. But you cannot say that we violated a constitutional provision on the basis of the 50-year limit. Yun lang po.
Mr. Chair, can I reply?
Kung Marcoleta, please proceed.
Thank you, Mr. Chair. Mr. Chair, there is no debate. I myself would concede that the 5th-year limit is subject to the discretion of the state. A franchise is a special privilege. Only the state, subject to its discretion, can extend the 5th-year limit. Ang pinag-uusapan po nito, kung sakasakali po ang isang applicant ay mapapatunayan na napakarami pong paglabag at questionabling hindi pagsunod sa mga kondisyonis ng kanyang prangkisa, katulad ng napapatunayang isa-isa sa pagdinig na ito. Nagamit ko na pong halimbawa yung isang manliligaw, sapagkat kahit karapatan niyang manligaw, Mr. Chair, kinakailangan naman po sigurong ipakita niya na deserving siya kung sakaling sagutin man siya nung kanyang babaeng napupusuan. Ito po ay isang special privilege. Isang pribilehyo para sa isang binata na ibigin siya ng isang babaeng napupusuan niya. Kung halimbawa po kakakitaan siya ng hindi mabuting asal, palagay ko po yung babaeng nililigawan, Mr. Chair, hindi magdadalawang salita, nabiguin niya po yun. Ito po ngayon ang punto ng pinag-uusapan. Isa-isa pong napatutunayan kasi. Ang dami na po ng paglabag. Nandun pa lang tayo sa citizenship, reacquisition of ownership, pagkatapos nandun tayo sa PDRs, ngayon po dito naman, sabi ko nga, this is a subject to the state's discretion. Kung ako pong tatanungin ninyo, hindi ko na po palalawigin. Saan pa po kayo makakakita ng isang kumpanya na isa-isang araw lamang, ulitin ko po yun, sa loob ng isang araw lamang, 3 batas ang pinagtibay para bigyan ng ABS-CBN at ang kanyang subsidiary ng 150 years. Isang araw lamang po yun. Saan po tayo hahanap ng isang kumpanya na nagkaroon ng ganong pribilehyo? Pagkatapos makikita po natin sa pagdinig natin ngayon, ang napakarami nga pong nakikita nating alingas-ngas doon sa pagsunod sa mga kondisyones na inilatag sa sarili nilang prangkisa. Kaya po sabi ko, kung akong tatanungin ninyo, I will apply the strict and restrictive application of that discretion on the part of the state. Wala pong debate na pwedeng palawigin. Ito pong 13 na kumpanya na inyong isinumiti rito. For the record, Mr. Chair, itong 13 ito, wala pong report na kinakitaan ng paglabag. Kaya po siguro ako naniniwala, pinalawig ang kanilang prangkisa. This is not the way to prove an argument, Mr. Chair. The burden of proof is in the application, in the applicant. Hindi po kami ang tatawag isa-isa rin dito. Ibig po ba ninyo sabihin, tatawagan namin ang Manila Broadcasting, Cebu Broadcasting, Philippine Broadcasting kung bakit kayo nabigyan ng prangkisa for more than 50 years? At the very least, Mr. Chair, siguro, pinuntahan nila, in-interview nila, nakita nila kung ano-ano yung mga paglabag siguro, tsaka natin siguro iisa-isahin. But this is not a comparable case, Mr. Chair. 13 in-approve ng Kongreso, maaaring sumobra sa 50 years. That there is no iota of evidence that these companies who were awarded repeated franchises ever committed any violation in the respective franchises. Unlike and in contrast to ABS-CBN, which is under the consideration of this August Hall. Salamat po, Mr. Chair.
Maari po ba ako mag-comment, Mr. Chair?
Sige, Attorney Bautista, one last na po bago tayo lumipat sa next
Maraming po salamat. Thank you po, Congressman Marcoleta. Una-una po, kami po ay kumaharap sa Kongresong to. Dahil sinabihan kami, nabibigyan kami ng patas at patag na hearing. Ang purpose po nitong congressional franchise hearings ay to determine the truth. Yan po ang sinabi sa amin. Ang ibig pong sabihin nun, bibigyan po kami ng due process. And an element of due process is a fair and impartial tribunal. Yan po ang nakalagay sa batas natin, due process. Kaya hindi po dapat nagko-conclude ka agad na ang ginamit pong salita, nag-aalingas-ngas at meron po kaming violations. Hindi po namin tinatanggap na meron kaming violations. Sa amin pong puso, wala po kaming violations. Yun lang po.
Maraming salamat po, Attorney Bautista.
Salamat po.
Ngayon po, susunod po si Congressman Edsel Lagman para sa kanyang manifestation. Kong Lagman.
Thank you, Mr. Chairman. This is a manifestation or a statement disputing the allegation that the more than 50-year operation of ABS-CBN Corporation disqualifies it from securing a renewal of its franchise under Section 11 of Article 12. The purported ban on the grant of legislative franchise to companies which have operated for more than 50 years is definitely another non-issue based on the following reasons. One, there is no constitutional provision or statute which prohibits the renewal or grant of a congressional franchise to corporations which have been in operation for more than half a century. The question is not whether Congress can grant a renewal or new franchise for another 50 years to the same franchisee, but the issue is whether Congress can deny a franchise because the applicant has already operated for more than 50 years without offending the due process guaranteed in our Constitution. In fact, there are innumerable corporations which have been granted legislative franchises despite their long period of operation of more than 50 years, like GMA7, Bohol Chronicle Radio Corporation, the Catholic Bishops' Conference of the Philippines, Raha Broadcasting Network, and Associated Broadcasting Company, or TV5. Among others, not to mention power or electric companies and telecommunication companies which have operated for more than 100 years. The provision in Section 11 of Article 12, which reads, and I quote, "No franchise, certificate, or any other form of authorization for the operation of a public utility shall be granted, etc., for a longer period than 50 years, only means that there must be a cap of 50 years for each franchise that the Congress may issue at a time. The limitation of 50 years pertains to every single franchise, but not on the accumulated years of operation by a corporation as a franchisee. Section 11 of Article 12 does not prohibit the renewal or grant of a legislative franchise to the same franchisee after the lapse of 50 years. A contrary interpretation is errant and counterproductive because it would be fraud and unconstitutional policy of disqualifying a corporation from securing a renewal or grant of a franchise because of, quote, old age, unquote. Corporations, like wine, become better due to the passage of time. Corporations which have been in operation for more than 50 years have tremendous investments, have gained invaluable experience and expertise, and have indubitable patronage. They should be allowed to continue serving the public and the nation instead of retiring them to oblivion. With respect to mass media, there is a special and more pertinent provision under Section 11.1 of Article 16, which reads, and I quote, "The operation and management of mass media shall be limited to citizens of the Philippines or to corporations, cooperatives, or associations wholly owned and managed by such citizens." Unquote. Nowhere in the provision is the effective life of a mass media enterprise pegged to a terminal of 50 years. Senior corporations must be recognized and awarded for the longevity of their public service instead of being discriminated against in the renewal or grant of legislative franchise. The Constitution did not envision or intend that the badge of uselessness must attach to corporations which have reached the golden age. Thank you, Joint Chairman.
Maraming salamat po, Congressman Lagman. Sunod po, babalikan na po natin si Congressman Caloy Zarate na binigyan nga ulit ng 5 minuto ni Congresswoman Arlene Brosas. Kong Caloy, meron po kayong 10 minuto.
Salamat, Mr. Chair. Nailinaw na po ito ng aking mga kasamahan yung usapin ng interpretasyon doon sa limitation ng 50 years under Article 12, Section 11. At kahit na ang mga tumututol dito sa pagbibigay ng prangkisa sa ABS-CBN ay inamin na rin na hindi ito usapin. In fact, Mr. Chair, in the first place, dapat hindi nga naging issue kung constitutional issue. Kung pwede bang ang isang kumpanya, pagkatapos may mabigyan ng prangkisa for 50 years, ay pwede pa ba uling bigyan ng Kongreso ng panibagong prangkisa for another 50 years. No? Dahil malinaw doon sa ating saligang batas na yung limitasyon na 50 years na yon ay for a particular franchise. No? Sa isang franchise na ibinigay ng Kongreso. Ibig sabihin, kung natapos na ang prangkisang yon at mag-a-apply uli ang kumpanyang yan, ay nasa karapatan o prerogative ng Kongreso na pwede siyang bigyan muli ng another 50 years or mababa sa 50 years. At yan po ang malinaw lang na limitasyon ng Kongreso. So hindi mo usapin dito, gusto lang mo nating linawin na Mr. Chair, no, na wala pang, kaya nga nagkakaroon pa tayo ng mga pagdinig ngayon, gusto nating malaman ang lahat bahagi ng mga issues na ito at sa aking pagkapalagay ay hindi pa tayo nagkakaroon ng desisyon. No? Ang committee ito na may nilabag ang ABS-CBN sa kanilang prangkisa at dapat hindi na siya bigyan ng panibagong prangkisa. No? Dahil ang pinag-uusapan natin ngayon sa isyong ito, ang isang kumpanya ba katulad ng ABS-CBN, pagkatapos ng kanyang current franchise ay mag-lapse, pwede pa bang bigyan ng panibagong prangkisa? At malinaw po, I think, as admitted, no, even by those who oppose the grant of a new franchise to ABS-CBN, na pwede pa naman. No? Ang sabi lang doon ay pag walang nilabag na sa prerogative ng Kongreso yan. No? So, hindi ko na po papalawigin na napakalinaw ng provision na yan ng ating saligang batas. May gusto na lang akong itanong sa ABS-CBN, Mr. Chair. No? Kanina nabanggit na ang prangkisa ng ABS-CBN ay naigawad noong June 21, 1969 for a period of 50 years. No? So kung susumahin natin yon, ang 50 years na yan ay dapat yung prangkisa na yan ay nag-lapse na noong 2019. Siguro ang katanungan ko po, Mr. Chair, ay ganito. bakit ang prangkisa ng ABS-CBN ay umabot pa ng May 4 of 2020 kung ang prangkisa nito ay naglapse, yung 50-year franchise na ay ibinigay pala ng Kongreso sa pamamagitan ng isang batas noong June 21, 1969, Mr. Chair.
Mr. Chair, may I be allowed to answer the question?
Please proceed po.
Yes, thank you, Mr. Chair. The franchise that was mentioned, the franchises that were mentioned were issued in 1970. Then martial law was declared, and in 1974, President Marcos issued his Presidential Decree 576-A, which terminated all congressional franchise by 1981. So that was the reason why there was a need for another congressional franchise in 1994, which ABS was able to secure in 1995.
Thank you for that answer, Attorney Poblado. So, nung magdeklara ng batas militar, tinake over ang lahat ng mga broadcast facilities ng ABS-CBN. And then, nabanggit ninyo, in 1981, naglabas ng isang kautusan si Marcos na ang lahat ng prangkisa ay wala ng silbi. No? So ang tanong ko po, in 1986 when ABS-CBN went back on air, no? April or September of 86, ano po ang naging basihan? Until 1994, ano po ang naging basihan ng inyong operation? Attorney Poblador, Mr. Chair.
Thank you for the question. We should go back to Act 3876 of 1931. That Act of 3846 is the first law which required congressional franchise for TV broadcast. However, with this PD 576-A, the congressional franchise under that act were all terminated effective 1981. After the termination of the congressional franchise, the permission was all granted by a regulatory agency, which was later on transferred to the NTC. Because of the cancellation of all franchises by PD 576-A, there was a confusion. Kailangan ba talaga ng congressional franchise or si NTC pwede na mag-issue ng permits? Nagkaroon ng understanding ang KBP, ang NTC, at saka ang Committee on Legislative Franchise that while this confusion still exists, the understanding is that the NTC will issue permits, but those who will be receiving those permits will have 2 years to apply for congressional franchise. And this understanding was confirmed by the Supreme Court in the case of Associated in 2003, which precisely identified this confusion.
Okay. Salamat, Attorney Poblador. Nabanggit ninyo kanina na in 1994, ABS-CBN did apply for a franchise which was granted by Congress. Is that correct?
Yes, Your Honor.
Ang tanong ko ngayon, yung prangkisa ba na yan na binigay noong 1995 was for a 50-year franchise or lower than 50 years?
It's for 25 years.
Okay. So it's for 25 years, beginning 1995.
Yes, Your Honor.
At ito yung franchise na hanggang May 4 of 2020.
Hanggang?
May 4,
Yes,
2020.
yes,
Okay.
that's the one.
Salamat, Attorney Poblador. So, nabanggit rin kanina, in 1969, 3 prangkisa ang ibinigay. One for ABS-CBN, one for Chronicle Broadcasting Network, one for another one. No? Sa inyong pagkakaalam po ba, pag ang isang kumpanya ay binigay ng 50 years, at isang kumpanya rin, another 50 years, and another one for 50 years, ibig sabihin ba, ang karapatan ng mga kumpanyang ito na mag-broadcast will be for 150 years. Mag-total ng 150 years.
Mukhang hindi ho. The reason why there were 3 franchises, they refer to the one franchise referred to radio, the other referred to TV broadcast. I'm not sure about the other one, but they are all separate franchises.
Your Honor, dadagdag ko lang po na yung ikatlong prangkisa was not an ABS-CBN franchise po. No, so yung isa po was a TV franchise for ABS-CBN, yung isa po was a radio franchise for ABS-CBN, yung ikatlo po hindi po ABS-CBN yan. Salamat po.
Thank you, thank you po. So ibig sabihin, kung may prangkisang radio for 50 years at ang TV ay may franchise for 50 years, ay hindi ho pwedeng pagsamahin nito para 100 years both radio and TV can operate. Hindi po ganon.
Hindi po ganon.
Hindi po ganon. Dahil malinaw nga po sa ating saligang batas na ang isang prangkisa ay talagang 50 years lang ang bisa niya. No? At kung ibigay man ito sa isang korporasyon, hanggang 50 years lang ang prangkisang yan. At ang Kongreso ay mayroong prerogative na ang prangkisang yan ay pwedeng hindi ibigay for 50 years. No? Gaya ng nabanggit ninyo kanina, nung mag-apply kayo in 1994, your 1995 franchise na binigay ng Kongreso ay 25 years lang ang binigay ng Kongreso. So, I think, Mr. Chair, malinaw na ito at ito ang pwedeng magiging ating batayan sa pagdinig na ito kung sakasakali na mabibigyan ng prangkisa ang ABS-CBN, ay usapin ito kung ito ba ay bibigyan ng 50 years or below lower than 50 years, gaya ng binigay natin in 1995. Dahil malinaw sa ating saligang batas na walang prerogative ang Kongreso na magbigay ng prangkisa sa isang pagkakataon sa pamamagitan ng isang batas nang lumampas ito ng 50 years. Dahil yan lang po talaga ang nakasaad sa ating saligang batas. So, dahil sa paglilinaw na yan, again, gusto kong irehistro dito, Mr. Chair, na nandito pa tayo sa usapin ng pagdinig ng prangkisa ng ABS-CBN. At I think that Chair will also confirm na hindi pa tayo nagkaroon ng desisyon ang committee ito na meron ngang mga nilabag na ang ABS-CBN magmula doon sa unang issue na ating pinag-uusapan hanggang umabot tayo dito sa usaping ito kung ang 50 years ba na yan ay lalabagin ng ABS-CBN kung bibigyan uli sila ng prangkisa. So, I hope na malinaw yan, Ginoong Chair, para po pagpunta natin sa iba pang mga usapin, ay ganun din kabukas ang ating isip sa pagtingin sa mga issues na ito. Maraming salamat, Mr. Chair.
Maraming salamat, Congressman Zarate. Ngayon, bago po natin ibigay kay Congressman Rufus Rodriguez, meron lang pong maikling manifestation si Congresswoman Biolago.
Thank you, Mr. Chair. Simple manifestation lang po. Ang RA 5730 was franchised for TV station for ABS-CBN only. And RA 5733 was a radio franchise po because the TV and radio were not granted in a single franchise. And then RA 5731 was a franchise for Manila Chronicle, which is not ABS-CBN. It's a totally different company po, Mr. Speaker.
I disagree, Mr. Chairman.
Kong Remulla.
I have a copy of the law here. Section 7 of the said law on chronicle broadcasting is here, and I will read it as a point of order probably. The title of the same act is hereby amended to read as follows: an act granting ABS-CBN, the Chronicle Broadcasting Network, a franchise to construct, maintain, and operate radio broadcasting stations and stations for television in the Philippines. That is Republic Act 5731. Republic Act 5730 and 5733, just for discussion, at least to clarify this, one refers to radio of ABS-CBN and the other refers to television. So you have two franchises, one for radio, one for television, and one for Chronicle Broadcasting Network, which is still an ABS-CBN corporation. For the record, Mr. Chairman, all three franchises were passed in the same day.
Thank you, Kong Boying. Thank you, Kong Mickey. Next to interpolate, Congressman Rufus Rodriguez, na kung saan binigyan din siya ng additional time ni Deputy Speaker Arenas, Congressman Tambunting, Congressman Garbin, at Congresswoman Violago. Kong Rufus, you are recognized.
Thank you very much, Mr. Chairman, and good evening to all our colleagues and our resource persons. First, I would like to ask questions to Assistant Secretary Professor T, if he is available in Zoom.
ASEC T.
Hello, Congressman Rufus, I am here.
Good evening, Professor T.
Good evening, sir.
As Assistant Secretary of the Department of Justice, which renders opinion as to different legal issues. You've read Article 12, National Patrimony, and Section 11. And do you see any ambiguity or doubt as to the import of this provision that no franchise certificate, other forms of authorization for the operation of public utility shall be granted except to citizens of the Philippines, etc. And then the last phrase is for a longer period than 50 years.
For us, Your Honor, there is no doubt as to what the 50-year limitation qualifies, and that the 50-year limitation qualifies the franchise itself.
Yes. And so therefore, there can be no doubt, there is no room for any interpretation, whether liberal or strict, because clearly that it just says that no franchise shall be over 50 years. And therefore, if the law is clear that every franchise, every issuance of a franchise from Congress cannot be more than 50 years, that is clear itself in the law. Is that clear? Is that clear to you, Assistant Secretary?
Yes, I would agree, Your Honor.
Thank you. And of course, in the case of the leading case of Republic Flour Mills Incorporated versus Commissioner of Customs 39 SCRA 269, it was stated there that when the law is clear, it is the duty of courts to apply the law. Is that correct?
Your Honor, I would have to refresh myself on that particular case, but on the principle that you stated, that is a correct principle, Your Honor.
When the law is clear, therefore, we apply the law. There is no need for Congress to consider whether to give a strict interpretation to this Section 11 or to apply a liberal interpretation, because the law is clear and there can be no more room for interpretation. And I would also ask you about whether when the law is clear and there is no interpretation, according to the Latin maxim, index animi, sermo est, speech is the index of intention. Speech is the index of intention, as decided in Alamo Garments versus NLRC 268 SCRA 497. Indeed, the speech that is written into this clearly states that every franchise, no franchise, can be issued but not more than 50 years. Is that again very clear in the law, ASEC T?
Your Honor, I'm not completely familiar with that particular maxim, but it appears to be just a version of what you stated earlier, that if the law is clear, we must not give further meaning to it. So I would agree, Your Honor.
Yes. So in that particular case, also, it comes to mind that there is another Latin maxim that is very clear in this particular case on the clear provisions of Section 11, Article 12. And it says, verba legis non est rescindum. From the words of the statute, there should be no departure. Would you agree with that particular saying, that when the words of the statute is clear, there can be no departure, there can be no putting of words into the section when it is very clear that the words of the statute say so.
Your
Do you
Honor,
agree
we would
with its
agree with
verba
that.
legis known as rescindum?
Yes, Your Honor, we agree. We agree with the verba legis principle.
Thank you very much. And so therefore, in this particular case, is there a provision here that after this, is there a provision in the section that says that no franchise shall be renewed by Congress? Is there anything that is found here?
Your Honor, the Constitution does not mention anything to that effect.
Yes, so it just says that for every issuance that no franchise more than 50 years. In other words, the Constitution says that Congress can issue franchises not more than 5 years at one given time. Is that correct?
Not more than 50 years at one given time, Your Honor.
That's correct. And so therefore, it is the view of the Department of Justice that as it is, this franchise, this particular provision is clear, and that therefore, we just have to apply the law. Is that correct?
That would be a good supposition, Your Honor.
Yes. And of course, also in the case of Ordillo versus Comelec, 192 SCRA 100, it is also established that in statutory construction or constitutional construction, like in this case, the language of the Constitution as it is, from the words no franchise up to not more than 50 years, should be interpreted in the sense that it has in common use and given ordinary meaning, that there will be no excess at one instance of more than 50 years. Do you agree with that, the case of Ordillo versus Comelec?
Your Honor, I'm not familiar with the case, but the principle that you stated on constitutional construction, we agree with it, Your Honor.
Thank you. And so it has also been decided in the central bank case that here the Supreme Court has not any occasion to rule on the issue because nobody will bring this to the courts because it is very clear. So it will be thrown out by the court if somebody would question that it is more than 50 years for a franchise given successively, not simultaneously, not one time more than 50. And so in this particular case, would you agree that the contemporaneous construction of this Constitution, because there's still no judicial construction, the contemporaneous construction is that you can see that Congress has construed this particular provision by repeating and repeating the issuance of the same franchise after the 50 years or 25 years. They're given another 25 or 50 years, and the construction of Congress, and it is public notice, judicial notice, that our laws are there. You can search it and on all the search methods, and that Congress, ever since it was established in 1907, Congress had been able to really just approve renewals of franchises already given before. Do you agree with that? The Congress has a contemporaneous, yes, construction of this, correct?
Your Honor, we acknowledge that there's no Supreme Court decision yet that specifically tackles this issue. But at the same time, we also acknowledge that Congress has repeatedly issued legislative franchises that would confirm the view that the 50-year limit pertains to the franchise and not to the grantee. And we likewise confirm that continued performance of Congress, continued behavior of Congress would suggest an interpretation by Congress that the 50-year limit does not apply to the grantee but to the franchise.
Thank you. So therefore, in the case of, I mentioned here just about 4 franchises on broadcast. And for example, the Philippine Broadcasting Service was given a franchise in 1950, again given in 1995. That will certainly be over already the 50 years plus. The third one is 2019, which will make it almost 100 years, because from 1950 for the Philippine Broadcasting Service, the same also with the Manila Broadcasting Corporation. These are all 1950 different broadcasting corporations. Manila Broadcasting, GMA Broadcasting Incorporated, Manila Broadcasting. These 4 are 1950s, and so therefore, up to this time, we say that's already 70 years. And because they were given in 2019, then they have additional 25 years. And the other one is 2018 and 2017. And so clearly, 3 times, the Congress has construed this provision that it is constitutional and it is proper to be able to give additional period of time, even exceeding, if you accumulate it, exceeding 50 years, as long as it is one franchise at a time, not more than 50 years. Do you confirm that?
Yes, Your Honor, that would appear to be the case.
Yes. So therefore, in this particular case, Congress has already made its own construction by giving almost 3 times for this particular broadcasting companies, and it will go to 100 years if you add all of this, including the new ones that were the third franchises given to these corporations. Now, it has also been stated earlier that the President and the Office of the President had signed this particular new extensions of renewals of 2019 for Philippine Broadcasting Service, 2018 for Manila Broadcasting, 2017 for GMA Network, and the President and the Office of the President had clearly have a contemporaneous construction of this law, seeing that there's no violation of it, had therefore construed this provision that it is clear and that therefore it is the President, Office of the President's construction contemporaneously that these particular extensions or renewals are valid and constitutional under our Constitution. Is that correct?
Your Honor, we cannot speak for the Office of the President, but
they signed.
Yeah, yes, but of course we can confirm that they signed these different legislative franchises, and by signing those legislative franchises, we can say that they believe that they weren't performing anything unconstitutional.
That's correct, because these are now existing laws, and they became law because of the signature of the President. So we thank you, ASEC, and I would like go now to the NTC, because the NTC also had contemporaneous construction under the central bank case of this particular franchise. So thank you, ASEC and Professor T. Thank you for your answers. And let me go now to Commissioner Cordova, Mr. Chairman. Thank you.
Present pa po si Commissioner Cordova. Kong Rufus, please proceed po.
Yes. Good evening, Commissioner Cordova.
Comsec, unmute po si Commissioner Cordova.
Ayan. Magandang gabi po, Congressman Rufus Rodriguez.
Good evening, Commissioner.
Opo.
I would like to ask that we lost you, or
Nandito po.
okay, good. Yeah, you're back on the screen. And mentioning about, for example, Philippine Broadcasting Service, 1950, franchise for 50 years, 1995, 25 years, 2019, 25 years. Now, do you agree that in the franchises given to them, the ones I mentioned, 4 of them, given in 1950, the same year, and were also renewed for twice, renewed. The franchise requires that after the franchise, they go to the NTC, correct?
Yes.
And what is the action according to the franchise? What should the NTC do after a franchise is given to, for example, these 4 companies, including also ABS-CBN?
They would ask for the provisional authorities, Your Honors, dun po sa kanilang mga radio stations and television stations.
Yes. Okay. And so you, being the commissioner of the NTC, would confirm that successively the Philippine Broadcasting Service, Manila Broadcasting, GMA Network, the Radio Mindanao Network of 1961, these particular franchises, you gave commensurately, gave the provisional authority, and later on the certificate of convenience and necessity. Is that correct?
That is correct, Your Honors.
So therefore, as a body which has primary jurisdiction under the doctrine of primary jurisdiction, you have also contemporaneously constructed interpreted the Constitution by saying that there is really no obstacle in you giving 2 renewals that would exceed the total of 50 years for these particular companies. Is that correct, that you have did issue this even if they are over 50 years already?
Actually, Your Honors, we just follow the law which is issued by Congress. Pag in-issue po ng Congress, that is a valid law at valid naman at okay naman po siya, then we just follow it and issue the required permits and licenses, Your Honors.
So therefore, you admit that Congress, the laws passed by Congress, including franchises, unless it is decided by a court to be invalid, is valid. And therefore,
Yes,
you yourself had been giving the provisional authority and giving the frequencies to these companies, even if they were more than 50 years already in existence.
That is correct, Your Honor.
Yes. So therefore, we can say that the NTC has been able to give that, and the companies, through the doctrine of appetitive fact, realize that their particular provisional authorities and certificates are valid because the NTC had been issuing after every franchise, even if it exceeds in total 50 years, but each franchise having a maximum only 50 years, then you therefore are saying that you have done this act. Is that correct?
Yes, Your Honors. That is correct.
And in all of these companies, these are all broadcast companies, in all of this, which you have given certificates of provisional authority, even if you cumulate them, it is more than 50 years you have given them. Has there been any instance where your certificate of public convenience on a second issuance or third issuance of the provisional authority, knowing that there may be over 50 years in total, had there been a question of your issuance of the subsequent provisional authority by anybody, and has there been any case that questioned you issuing to this GMA network, Manila Broadcasting, Philippine Broadcasting, and ABS-CBN, had there been a question of your act as the primary jurisdiction body to any court? Has there been any question?
As far as I know, Your Honors, wala naman po.
So nobody has questioned this, because also everyone really agrees that there is really a very clear provision in the Constitution. And so therefore, you therefore agree that what you always confirm that you have issued all of this as a matter of course, and following Congress and following the law, and that all of these companies are still operating up to now.
Yes, Your Honors.
Thank you very much, our Commissioner of the NTC, for confirming that. So, Mr. Chairman, in conclusion, it is very clear that the Department of Justice, who gives opinions to our executive branch, has admitted that there is no ambiguity on Section 11. And therefore, when there's no ambiguity, there is no need for Congress in deciding to give this particular franchise or not, would take into consideration that is over 50 years. That is not a consideration, Mr. Chairman, in the grant. Other issues are there, but certainly this is a non-issue at all, because certainly this is particularly a situation in the Congress, in the Constitution, that it is very clearly stated in this particular provision of Section 11. So clearly, also, contemporaneous acts of the Executive Department has already gave imprimatur to all these renewals that will already exceed 50 years if you total the different renewals. And to repeat, the Congress had already passed through all the procedure, from the filing to the first reading, second reading, and then third reading, then goes to the plenary, and then to the third reading, it goes to the Senate. And so, therefore, it is clear that we in Congress, we always have been saying and implementing this Constitution without interpreting it and implementing it, that it will be for only no franchise, not more than 50 years at one given instance, but then it has been renewed, and Congress has given its approval of this kind of observance of Section 11. Likewise, we always also have the President. No less than President Duterte had signed the GMA Network 2017, Manila Broadcasting 2018, and Philippine Broadcasting Service 2019. And therefore, the President and the Office of the President and the legal Office of the President has given the President the advice to sign it because it does not violate any constitutional provision. And finally, the body which has the jurisdiction, primary jurisdiction on this particular matter of allowing the operation and giving the frequency of agency or a company that has been given a franchise, has also confirmed that they have been extending and renewing this and giving the provisional authority. Therefore, Mr. Chairman, it is crystal clear, very crystal clear, that this is an issue and we should proceed now to other issues, because this issue is again dead. This issue is very clear. It is clear in the Constitution, clear by extemporaneous construction, and therefore this issue had no bearing at all in this franchise application of ABS-CBN. Thank you, distinguished chairman. Thank you, my distinguished colleagues. Thank you, our resource persons, and all my colleagues in Congress. Thank you and good evening.
Thank you, Kong Rufus. Next, I would like to recognize Congressman Lito Atienza.
Mr. Chair, can I interject?
Kong Marcoleta, si Kong Lito po muna and then kayo po sunod.
Okay po, salamat po.
Can you hear me, Mr. Chairman?
Yes po, Kong Lito. Please proceed po.
Thank you for finally allowing me to join the discussion. Malinaw na po yung paliwanag ni Congressman Rufus na yung ating konstitusyon ay hindi po nilalabag ng ABS. Yung kanilang application may be acted on by Congress. Pwede natin bigyan ng 1 month franchise up to maximum of 50 years. Yun po ang konstitusyon eh. Si Congressman Marcoleta lang po naman ang merong ibang impression, ibang interpretation. And again, he cites the Constitution and a violation thereof in this particular issue. Can I ask the gentleman representing ABS, Attorney Bautista, a simple question? Pwede po ba? Andiyan pa po niya. Andiyan pa po ba si Attorney Bautista?
Attorney Bautista? Andiyan pa po, Kong Lito.
Nais ko lang liwanagan yung paulit-ulit na sinabi ni Congressman Marcoleta na meron siyang sinasite na 3 batas na nagbibigay ng 150 years franchise sa ABS. Totoo po ba yan o hindi? You were not given a chance to answer that very clearly. I'm asking you now. Did you ever enjoy a 150-year franchise?
Hindi po. We never did.
Alam ko po yun. Alam ko, and I agree with you. I just wanted that on record because Congressman Marcoleta was browbeating you. He was not giving you a chance to answer. Again, he's alleging a constitutional violation, but there is none.
Okay lang po yun. Okay lang.
Ang nakuha niyo yung prangkisa, kailan po ba? Yung latest?
79. I think Attorney Poblador can answer that question. I'm not sure when we got it.
I will answer it. 1995.
1995. 25 years.
Kaya nga po, paso na ngayon. Ngayong 2020, it is now terminated or expired. That's the reason why you're applying for a new franchise.
Yes, sir.
So malinaw po sa akin, hindi lang malinaw kay Congressman Marcoleta, na unang-una, wala kayong nakuhang 150 ever.
It's being used by the gentleman from the party list, Buhay. He used the word browbeating very unparliamentary language, and I move to strike off the record the remarks of the gentleman from Buhay Party List
Mr.
to do with Congressman Marcoleta in the sense that he demeans the
Mr. Remulla, I am not willing to be corrected by you because you also have been monopolizing these proceedings. This is a congressional hearing.
Can you kindly suspend the rules, Mr. Chairman?
Suspended for a few minutes. Hearing resumed. Congressman Atienza, you have the floor. Pero remind ko lang po sana na refrain po natin na tukuyin yung ating kapwa at para hindi po maiwasan po natin na meron tayong mga arguments.
Mr. Chairman, may I know what the action of the committee is on my motion to strike off the record the unparliamentary remarks of Mr. Atienza?
There's a motion by Congressman Remulla. Any second?
We object that. We object to that. We strongly object to the objection of Congressman Remulla because he's also one who has been monopolizing these hearings.
Yes,
we are a 305-member Congress, and this committee represents the Philippine Congress. Kaya sana'y maging mas mapagbigay sila. Immediately magre-react siya ng ganyan. Nangangahulugan lang. Tama po yung aking damdamin na itong hearing natin ay hindi po natin inilalagay sa tamang direksyon. For us to be very parliamentary and strict about our language, I think you should also respect the feelings and sentiments of those who may not be agreeing with what you're saying, with what our colleagues are stating on the floor.
See for a ruling, Mr. Chairman.
Hearing suspended again for a few minutes.
Session resumed. Sa ating pong galang-galang na Honorable Lito Atienza, sa ating pong elder statesman, ang hiningi lang naman po ng ni Congressman Remulla ay yung pong wag po tayong magtukuyan dito sa loob ng ating hearing sa ating komite at kinikilala naman po yung mga puntos na niraise ninyo. Doon po sa binanggit nyo, Honorable Atienza, tungkol po doon sa pagkakasunod-sunod ng mga nagtatanong at nagsasalita. Pag po ninyo, hindi po kami ang nagdedetermine yan yung nasa floor. Everyone is welcome to attend the committee hearings. Ito po yung dinedetermine ng chairman ng Legislative Franchise Committee and the Committee on Good Government. So, Congressman Atienza, with your indulgence, I will rule to strike off the word probity and your reference to Congressman Marcoleta. Pero maaari na po kayong magpatuloy sa inyong mga pagtatanong. So ruled. Congressman,
Mr. Chairman, may we just continue by way of manifestation? Dahil wala na po yung issue constitutionality nitong franchise application. Under the Constitution, it's very clear. No one franchise should be more than 50 years. They're not applying for a 51-year franchise. They're applying for a renewal of their 25-year franchise. So it is within the powers of Congress to determine this. And all I request, Congressman Marcoleta, who is enjoying, obviously, immense advantage in these hearings because pag siya nagsasalita, hindi po niyo ini-interrupt, hindi po niyo pinipigil. Pag kami po nagsasalita, masyado kayong maigpit. Ngayon gusto pa ninyong paalis yung aking ginamit na kataga. Wala pong masama rin sa browbeating. Talagang meron po kayong...
With your indulgence, Congressman. Yung pong nangyari po kasi kay Congressman Marcoleta, yung pong mga oras ng iba ibinibigay sa kanya. Pero if you recall, Congressman Atienza, he never refers to anyone or any member of the committee. And if I may, Congressman Atienza, you're raising a good point. Please continue with that. Kung maaari po sana, wag tayo ang mag-away-away kundi po dun sa issue ng Constitution. Congressman Atienza, salamat po.
Anyway, gaya na sinabi ko po, tapos na yung issue sapagkat malinaw po ang saligang batas. Hindi po totoo na hindi pwedeng tumagal na mahigit 50 taon ang nag-e-enjoy po ng prangkisa. Pwede pong 100 taon. At kailangan korekin ko lang yung sinabi ni Congressman Marcoleta na nabigyan daw ng 150-year franchise itong ABS noong 1969. I'd like that question to be answered by him. Pwede po bang tanungin siya? Saan po ba ninyo nakuha yung impression na nabigyan ng ABS ng 150 years franchise noong June of 1969? I want that answered for the record. Dahil for the record, sabi niya, ang swerte naman itong korporasyon na ito. Nabigyan na ng 150, gusto pa ng additional. Samantalang marami kaming question on the constitutional violation. Again, ako po'y sinundan ko itong hearing na ito. From the beginning, although mag-a-apply ako for interpellation, ako'y number 30, 34, ngayon naman number 17. Kaya pinagsagaan ko na. Dahil gusto ko namang marinig yung tinig ko. Kami po sa Buhay Party List, patas. Kami po ay nagtatanggol ng karapatan ng lahat upang magkaroon tayo ng mas maayos na pamumuhay. Buhay Party List kami. Anyway, to manifest my continuing strong sentiments on the continued allegation of violation where they have not proven anything up to this point in time. After 7 hearings, wala pa po silang napapatunayan. Humihingi sila ng records, meaning they're on a fishing expedition. Congressman Edsel Lagman talks from records existing. Congressman Rufus Rodriguez talks from records that he's holding. Yours truly, although I'd like to accept some of their allegations, kaya sinusundan ko, baka merong sasabihin talagang may katotohanan na ang ABS na nag-violate. Katulad po nung pagkakasoli sa kanila. Ako po isa sa mga players ng EDSA Revolution. Kaya I am very well aware of what transpired during that period. How the Lopezes were deprived of their property. ABS network was taken away from them. Use whatever word you would want to use. Hindi nagbayad, ginamit ng administrasyon ni Mr. Marcos. Noong dumating ang revolusyon at nanalo ang taong bayan, isinauli yung kinuhang ari-arian. Ano pang pinag-aaralan natin? Ang tanong ko nga sa marami, kung kayo, yung bahay ninyo, inagaw ng isang opisyal ng militar under martial law, huwag na si Mr. Marcos, nawala sa inyong control, nawalan kayo ng bahay at ari-arian. Nanalo ang revolusyon ng bansa, naibalik sa inyo yung bahay. Pagtatalunan pa ba natin? O may television dyan bago, o meron dyan oven. Unfair, illegal, unconstitutional. Kaya po medyo nababagabag po naman ang inyong lingkod. Baka kung saan mapunta itong hearing eh. This is not an investigative court of law.
Kaya yung mga hinihingi po mga dokumento, at mga prueba to prove their points, para sa akin po hindi tugma sa dapat nating ginagawa. Ang pag-aralan natin yung pakinabang ng bansa sa operation ng ABS-CBN. Ako po hindi tao ng ABS at may reklamo rin po ako. Sapagkat nung kampanya ng 2016, ako po nagbayad ng mga advertising spots. Tananggap naman yung pera ko. Pero hindi po in-air yung aking spots. Kaya right after election, sinulatan ko ng formal ang ABS. Soli niyo yung aming binayad. Yung pay before breakfast is one-sided. You charge us, we pay, and then you don't air, you have to give us back our money. Immediately, binalik po naman ng ABS at nag-apologize. Dahil talagang sumobra ang kanilang kinuhang spots, advertising spots, hindi nila na-air lahat. Ang aking pakiusap sa mga kasamaan, sama na po si Congressman Marcoleta, Congressman Barsaga, Congressman Remulla, nakikiusap ako sa iyo. Luwagan natin ang ating pananaw sa hearing na ito. Let us stick to the genuine issues of whether ABS has violated the Constitution or not. I've heard the Department of Justice, the Immigration, and one of the most prominent immigration commissioners we've had in the country is Commissioner Rufus Rodriguez. Siya po ang maraming reformang nagawa sa immigration. Narinig na rin po natin ang SEC. Wala pong violation sa PDR. E ngayon po, pinag-uusapan itong nagpas na sa prangkisa ang ABS sapagkat limitasyon daw. Yun ang interpretasyon. And I have to mention the name because talagang galing sa kanya. Yung kanyang allegation from the very start, ABS violated the Constitution repeatedly and one of which is applying for a franchise where they have already in operation beyond 50 years. But they have not gotten any franchise for 50 years even. Congress has the power to give a one-day franchise or a 50-year franchise. But the ABS has not enjoyed a franchise more than 25 years so far. So I am constrained to clarify everything so that we may proceed with care. Kung gusto ninyong pagbigyan si Congressman Marcoleta sa kanyang repeated questioning on the constitutionality or violations of thereof, okay lang sa akin. Total, ang boboto po dito noon sa plenaryo tayong lahat. Yung boto niya isa. Yung boto po ni Congressman Atienza, isa rin. And therefore, in the final analysis, ito yung desisyon ng buong Kongreso. Subalit, huwag naman tayong magmukhang one-sided, bias sa mata ng tao. Ang tanong po sa akin sa labas ganun lang palagi. Kayo ba talaga bang desidido kayong wag bigyan ng prangkisa? Sabi ko, bakit ganun ang impression ninyo? Napapanood po namin yung paratang ng isa ay paulit-ulit na hindi binabago. Bagamat nagsasalita na autoridad. Paniniwalaan ba natin yung kasama nating congressman who may not agree with the Department of Justice, with the immigration officials, with the Securities and Exchange Commission? Yung citizenship issue, hanggang ngayon, issue pa rin sa kanila. Malinaw na malinaw po dual citizen. Hindi naman dininay ni Mr. Lopez. I am an American citizen by virtue of my being born in America. Under American laws, that makes me an American citizen. Ang reaction doon, ang swerte mo naman. At talagang swerte nga siguro. Kayo, pag pinanganak kayo sa Amerika, American citizen kayo. Pero ako, personal, hindi po ako naiingit doon. Hindi ko masasabing swerte kayo. Maraming problema Amerika ngayon. I wouldn't want to be an American citizen. But Gabi Lopez is a natural-born Filipino. But my point is, why can't we accept the answers of the other side? Lest we be branded as biased, and we are already decided on the issue. So to clarify it, Mr. Chairman, I have my highest regard for you. You are an old friend. I've been a member of this committee for so long, and you already are very familiar on how we have dealt with applications for franchises. Itong application na ito ay isinampa dito sa committee ninyo. Ang hinihingi ko lang, take better control of the proceedings, as this is not a committee of one congressman or two congressmen or 3 or 4. This is a committee of 305 members of Congress duly elected by the people. And the earlier we agree on this, isampa na ninyo sa plenaryo. Pagbotohan na natin, anyway, narinig na natin lahat ng argumento. Hahanapin pa ninyo yung pagkukulang ni Cory, pagkukulang ni... ang makakapagbigay po ng malinaw na sagot dyan, ang Pangulong Cory. Under the Freedom Constitution, she was free to become a lawmaker and the chief executive. Alam ni Congressman Rufus yan. Binanggit nga niya, we were under a revolutionary government at that time. We had a suspended constitution. We had a freedom constitution. So I don't know what they are looking for. Even if they are able to find any fault, sasagutin lang po yan ng mga abogadong batikan. Wala na po yung taong nagkamali. Sino po ang ating parurusahan yung tumanggap ng benepisyo? Palagay ko hindi po. Husgahan natin ang ABS on the basis of their contribution to national development and, of course, the protection of the rights of every citizen and public service all the time. Yun po ang nakikita ng marami sa ABS. Kaya marami po tayong ipaliliwanag pag dito nagkamali tayo ng ating pamamaraan. I urge the chairman of both committees, Chairman Defensor is another member, another chairman of another committee. Be more magnanimous and be more broader in your vision and appreciation of facts. Hindi yung gusto lang ninyo. Ano ang batas at ano ang katotohanan. Maraming salamat po sa pagkakataon, Mr. Chairman, and I trust that you will take heed to my admonition and my simple advice. Ituwid natin ang pamamaraan sa committee ito. Salamat po.
Thank you. The Honorable Lito Atienza of the Boy Party List.
Kong Mike.
Yes.
May dadagdag lang ako, no? Congressman Atienza, simulat sa po naman, ang ginagawa nating committee is binabalanse po lahat. Ngayon po, kung labas po, ang dating po sa inyo ay one-sided, at tingin ko po, I beg to disagree kasi tingin ko po, patas naman po, lahat po may chance magsalita. Tulad ng sinabi niyo, matagal na po kayo member ng committee ko. Lahat po, kahit nga po hindi membro ng committee, hinahayaan ko po magsalita dahil gusto ko po lahat magkaroon ng chance na mailabas ang kanilang side. So dito naman sa committee na to, hindi rin po natin naman maisisisi kung Atienza, kung marami po nagbibigay ng oras na iba nating mga kasamahan, kila kung Marcoleta, kila kung PD, o kung sino pa man. At hindi naman po yan na sa kanila lang marami nagbibigay ng oras. Kay Kong Rufus, marami rin po nagbibigay. So patas naman po ang ating pagpapatakbo ng ating hearings dito. Yan po ang amin talagang pinagsisikapan kung Atienza. So doon po sa inyong observation na one-sided, I take exception po kasi pinaghihirapan po talaga namin ni Kong Jonathan na gawing patas po dito. So maraming salamat po Kong Atienza, and doon po sa inyong reklamo po na kayo po ay lagi napapahuli sa listahan. Siguro po mas maganda niyan, kung meron kayong tatanong, mas maaga po kayo magpalista no, sa ganyan, malagay po kayo sa medyo taas. Maraming salamat po. Kong Mike Defensor.
Thank you, Chairman Chicoy Alvarez. Paalala lang po, maraming salamat Congressman Alvarez, maraming salamat Congressman Atienza. Paalala lang po sa ating mga kasama, sa ating pong pagdidebate, no, we recognize the decorum of the committee. Now we conduct ourselves. Kung pwede po, wala ho tayong referral to one another. We address the hearings and conduct ourselves and we address the chairman, the presiding officer of the committee. Maganda po yung mga inisyo nyo, Congressman Atienza, and I understand you, Congressman Alvarez. Talaga pong yung pagbabalansa ninyo ni Kong John Alvarado sa isang issue napaka-init, talaga naman pong napakahirap. Hindi lang po yung issue, mismo yung mga miyembro ng komite kung paano nyo ililinya kung sino yung magsasalita. So with that, I now recognize...
Mr. Chairman,
yes.
may I raise a point of order, Mr. Chairman? We are now here debating about a franchise or discussing a franchise that has expired and a CDO was issued by the NTC. We're talking about the law here, Mr. Chairman. The NTC, a cease and desist order was issued by the NTC asking ABS-CBN to cease and desist from broadcasting. Now, we were in receipt of a provisional authority of the NTC given to ABS-CBN on May 14, 2019 on digital migration. And in here, there was a phrase which said, wherefore, premises considered, then I will detract from that. The Commission hereby approves the conversion from analog television service to digital terrestrial television broadcasting station of ABS-CBN Corporation using Channel 43 of Metro Manila, predicated upon its congressional franchise under RA 7966. Meaning to say, this provisional authority was granted to TV Plus. TV Plus, a product of ABS-CBN, migrating to digital. The question here, Mr. Chairman, is that earlier I saw a television set where there was a teleradio program airing on TV Plus. Teleradio, or DCMM, was broadcasting on TV Plus. By what authority is the teleradio broadcasting on TV Plus, Mr. Chairman?
Honorable Remulla, without point of order, without waiting for the explanation of NTC, I'm ordering on TC to make a written explanation for our next hearing. If that explanation can be given to us even before that hearing, it will be better if it can be sent to the committee secretariat at pwede pong ibigay sa atin.
So, Mr. Chairman,
ang sinasabi ni Congressman Remulla, ang point of order niya, ginagamit yung free air, ginagamit to sa TV Plus, and therefore, you're calling the attention of NTC. Tama po ba?
Yes, Mr. Chairman, because the CDO should also apply to TV Plus and all activities of ABS-CBN on TV Plus, just for the record, because we were in receipt of this provisional authority from them. Therefore, they must be obeying the same authority, the provisional authority that they granted.
Okay, thank you. NTC is ordered to give us a written explanation, and because that will be the subject of discussion in the next hearing. So ordered. Congressman Marcoleta is recognized.
Thank you, Mr. Chair.
Before you continue, I will now relinquish the presiding duties to Honorable Alvarado.
Thank you, Mr. Chair. Mr. Chair, may I ask a few questions from the representative of DOJ?
Maaari po.
Nandyan pa po kaya siya, Mr. Chair?
Nandito po, Your Honor.
Yung ng DOJ, ipaalala po natin sa lahat na kung po inyong nasubaybayan ng ating hearing, ay pinipilit po talaga nating maging patas ang ating hearing. Sa sobra po nating patas ay lahat ng sumobrang oras na kinonsumo ng mga nagtatanong ng antay sa prangkisa ng ABS-CBN, yung mga kontra po sa prangkisa ng ABS-CBN, ay ibinigay naman natin sa mga kampi sa prangkisa ng ABS-CBN. Sana po ay huling pagkakataon na pong masasabihan na hindi patas ang pagdinig na ito. Gayon din po ay parati pong kinakausap ng mga chairman ng joint committee ito, ang ating mga panauhin, kung meron silang mga panaghoy na gustong sabihin sa chairman, ay tutugunan naman natin. Maaari na po kayo magpatuloy sa inyong pagtatanong, Congressman Marcoleta.
Salamat po, Mr. Chair. Nakikinig pa po ba yung representative po ng DOJ?
Nandito pa po ako, Your Honor.
Salamat po. The first question po ay, is your office, the DOJ, competent to interpret any provision of the Constitution?
Your Honor, whenever we render opinion for different government agencies, our opinion is always, the focal point of our opinion will always be the law and the Constitution. So yes, Your Honor, this is one of our powers, Your Honor.
You're saying that your office is competent to interpret the Constitution?
Your Honor, we render opinions, but these opinions are not binding, unlike court decisions. They are merely persuasive.
But you are limited to issuing opinions, is that correct?
Yes, Your Honor. That is correct.
It is handbook doctrine that whatever opinion that you formulate in the DOJ is only tentative. It's preliminary. It's not conclusive, and it is not even binding to the court.
Your Honor, the more appropriate word for us is persuasive. The opinions of the DOJ are not binding, they are merely persuasive.
Mr. Chair, medyo nahihirapan po kung what did you say?
Sorry, Your Honor, mahina po signal. Our opinions are not binding, but they are persuasive. That is the word that we usually use to describe our opinions.
They are persuasive, but they are not conclusive and binding to the court, correct?
They are not, Your Honor. They are not binding on the agencies to whom we render opinions. The agencies are free to disregard our opinion if they want.
And the answers you have just given to the questions of our colleagues earlier were also opinions from
Your
your
Honor,
view. These are
that is
basic
correct.
and they are not binding to this body. Is that correct?
That is correct, Your Honor. They are merely persuasive to this body as well.
Because only the Supreme Court is empowered by our Constitution to finally settle dispute, legal dispute, and even in interpreting any provision of the Constitution.
That is correct, Your Honor.
Yeah. Yun pong mga sagot po ninyo kanina sa mga nagtanong pong mga kasama namin. They are persuasive at most, but basically, we may or we may not rely on those answers. Is that correct?
You may disregard these answers, Your Honor.
Okay. As a matter of fact, even the MTC as an administrative agency or any quasi-judicial body for that matter, if ever they make any opinions, the same treatment is accorded. They might be persuasive, but basically tentative. And again, this will not bind the court, not even this body. That is correct.
That is correct. You are free to disregard our opinion.
As a matter of fact, sir, even the House of Representatives is not even competent to interpret the law because only the Supreme Court can do it. That is correct.
Your Honor, if I may qualify, Your Honor, the House of Representatives and especially the executive, the DOJ, and I would think any other department or agency in the executive should be allowed to perform their function of executing or administering the law, even in the absence of any Supreme Court decision. It doesn't mean that if the Supreme Court has not ruled upon a particular issue, that we can just simply wait and not do anything. In the absence of Supreme Court decision or Supreme Court interpretation,
Pwede po ba kayong gumamit ng kasi talagang medyo mahirap po, garbled po ng konti.
Medyo masama po signal dito sa bahay. Your Honor, tama po kayo na Supreme Court ang final arbiter ng kahit anong mga legal issues natin dito. Ngunit, mahirap naman po sabihin namin sa executive na kailangan kami maghintay ng sabi ng Supreme Court bago i-execute ang isang batas, no? O ang konstitusyon, na kailangan namin hintayin ng Supreme Court na bago magbigay ng opinion, lalo na kung hinihingi ito ng isang body tulad ng Congress. So habang wala pong interpretasyon ng ang Supreme Court, ang ginagawa po namin ay to rely on principles of statutory construction as well as jurisprudence to come up with our opinion, Your Honor.
Tama po yun. Wala po tayong pagkakaiba sa pangunawa doon. At kagaya nga po nito, naharap po tayo sa isang issue kung saan yung 50-year limit ay binibigyan po natin ng kaukulang pansin. Mapapansin po ninyo kung babasahin po natin yung provision kanina, ito po yung not more than 50 years, not longer a period of 50 years. Maniniwala po ba kayo kung sasabihin ko sa inyo na wala namang binabanggit doon na talagang renewal? Wala pong salitang renewal, hindi po ba?
Tama po, wala pong salitang renewal sa provision ng Constitution na yun.
Basta hindi po siya open-ended. Basta sinabi, not more than 50 years, period. Wala pong sinasabi na pwedeng i-renew, hindi po ba?
Ang sinasabi po niya, the franchise shall not exceed a term of 50 years.
Opo, basta wala pong mababasa doon na, let's say, subject to renewal. Wala pong ganun. Basta period na po siya, not more than 50 years, period.
Wala po. Walang nakalagay na subject to renewal, Your Honor.
Ngayon po, dahil sa wala namang napagbabasihan na record sa Constitutional Commission na pinag-usapan man lang nila na naulinigan man lang natin na nakalagay, pwede ba nating i-renew ito o kaya ano kaya sa tingin natin? Gusto mo bang ilagay natin yung condition na pwedeng i-renew? Wala po tayong mababasa kasing nakalagay doon ASEC, hindi po ba?
Opo.
Kaya nga,
Your Honor,
kung tutuusin talagang nasa wisdom na lamang po ng Congress, discretion niya po talaga, kung i-renew niya po. At yun naman talaga ay nasa kapangyarihan naman ng Kongreso, nahatulan po, hindi po ba?
tama po yun. Pwedeng i-deny ng Congress ang renewal.
Opo.
Ngunit hindi po pwedeng basehan ng denial na 50 years ang maximum term ng isang holder ng franchise.
Kaya po, dahil sa naharap po kami sa usapin na ito, ang aplikasyon po ng renewal ng ABS-CBN, nakalatag po sa harapan namin ngayon. Kaya dinidinig po natin, para sa ganoon, magkaroon ng kaukulang batayan po kung ito po ay i-renew o hindi. Ang naging posisyon ko nga po, kung ako po yung tatanungin, kasi sa pagsusuri ko, ganito po yung aking nakikita. Kaya dahil sa ang Kongreso na mayroong prerogative na either i-renew niya o hindi, wala naman pong makapagsasabi na basta't nag-apply ka, automatic pong i-renew sapagkat hindi nga nakasulat. Tama po?
Tama po yun. Consistent po yun dun sa sinasabi natin na ang franchise ay isang privilege. At ang Congress ang kinatawan na magbibigay ng privilege na yun.
Tama po, sapagkat ito ay isang special privilege na binibigay po ng Estado natin.
Tama po.
Okay. Yun lamang po, Mr. Chair. Salamat po ng marami.
Thank you.
Maraming salamat, Congressman Marcoleta. At para po sa huling magtatanong ngayong gabing ito, kinikilala po si Senior Majority Leader Boying Remulla, isa rin sa mga Vice Chairman ng Joint Committee ito. Nabinigyan po ng oras ni Majority Leader Romualdez at Deputy Majority Leader Sharke Palma.
Mr. Chairman, I think that we have discussed this already fully, this issue. So rather, I would think I would just file my favorite motion. Move to adjourn, Mr. Chairman. Or move to suspend until Monday, Mr. Chairman.
Thank you, Deputy Majority Leader. Hindi mo nagamit yung 15 minutes mo, Vice Chairman.
I will use it for the next meeting, for the next hearing, Mr. Chairman, on the next topic.
Sige po. Papaalalahanan lang po ang ABS-CBN na kailangan na po ninyong magsumiti ng mga kaukulang dokumento tungkol sa labor bukas. Hanggang alas 3 po bukas ay hihintayin po ng committee ito. Lahat po ng isusumiti ninyo para sa usapin po natin sa Tuesday. 1 p.m. po ulit, 1:00 ng tanghali, Tuesday, magkita-kita po ulit tayo. At sana po ay mas maayos na po yung hearing natin kaysa po sa hearing na naranasan natin ngayong gabi. Ang chairman po, isa po sa mga chairman ng committee ito, ang inyo pong kuya ay nalulungkot sapagkat nagkaroon ng konting kaguluhan ay patapos na ang araw ng ating hearing. Sana po mas maging parliamentary at mas maging maayos po tayo sa susunod na hearing. Ito po muli ay gagawin sa Tuesday. Sa Lunes naman po ay magkakaroon tayo ng hearing hindi naman po kasama ang legislative franchises, ang Blue Ribbon Committee, ay magkakaroon naman na hearing patungkol sa social amelioration nakatuon sa DSWD. Para po sa may mga katanungan tungkol po sa usaping ito, kayo po ay inaanyayahan via Zoom at dito sa loob ng plenaryo. Maraming salamat po sa inyong lahat. There's a pending motion to suspend, duly seconded, hearing no objections, hearing suspended.
Hearing suspended.